Hello, everyone, and welcome to this Global Public Law Seminar coming to you from the Centre for Comparative Constitutional Studies at Melbourne Law School. I'm Adrienne Stone and I'm the Director of the Centre. I would like to begin by acknowledging that Melbourne Law School is on the traditional lands of the Wurundjeri people of the Kulin Nations, and I pay my respects to their elders past and present. And I should note that I'm also speaking to you from Wurundjeri land today, where I am fortunate to live and work. It will be my task to introduce the panelists today. We will have a discussion of my colleague, Professor Andrew Kenyon's wonderful book, Democracy of Expression, Positive Freedom of Speech. And I'm so pleased that we have a collection of very distinguished freedom of speech scholars who join us, and they really put the global in global public seminar series. So we're welcoming them all from very far away. So I will introduce them in the order in which they will speak. They will each speak for 10 minutes, and then Professor Kenyon will offer some responses to their comments before we have a facilitated discussion at the end. So we will hear first from Dr. Ioanna Tourkochoriti, who is a legal scholar at the Law Faculty of NUI Galway. Welcome, Ioanna. Then we will next hear from Associate Professor Girard, who is an Associate Professor in Legal Philosophy at the University of Lyon. He will be followed by Professor Dr. Mathias from Kiel University in Germany. And then lastly, we will have Professor Jacob Rowbottom, who is a Fellow of University College, Oxford, and a Professor of Law at the Faculty of Law at Oxford. So welcome to all four of you. Thank you for joining us. Lastly, I should welcome my colleague, Professor Andrew Kenyon, whose wonderful book we are discussing today. So thank you, and over to you, Dr. Tourkochoriti.
Thank you very much. I am delighted to be participating in a discussion of Andrew's extremely interesting and important book. The book engages with a wealth of materials on freedom of speech, and the author analyzes the most important literature in this area and engages with it creatively. And the book also engages with the case law of German and French constitutional courts on the topic. It brings very nicely theory and case law together in a very sophisticated analysis towards proposing a framework for communicative freedom. Andrew argues in favor of positive action of the state to help the citizens realize their freedom of speech and communication. He emphasizes that it is important to imagine a constitutional right to free speech that includes positive as well as negative dimensions. He offers some elements related to what positive free speech involves. There is a need for genuine distribution of communicative power through measures such as funding levies and transparency requirements for political media relations, as well as substantially reformed governance of algorithm-driven services, for instance. Andrew argues that if free speech has a very important role, if it is the constitution of the constitution, as Eric Heinze also has noted, courts have a very important responsibility in realizing speech. Speech has a social organization, Andrew notes, which extends well beyond law. In other words, democracy is a social state as much as a political institution, and a democracy cannot function without some degree of equality within civil society. Democracies need speech, and they need equality in speech rights. These rights involve also citizens having the preconditions that they need in order to be able to express themselves. Andrew's phrase is, sustained plural public speech is required for democracy to have communicative legitimacy. Thus, it is extremely important to eliminate the structural disadvantages that some citizens have. Andrew emphasizes the role that constitutional courts should play, and he criticizes cases where in Europe courts have fallen short of the role that they should play in this area. Sufficient action by legislatures or executives is fairly unlikely, Andrew notes, because political actors are too deeply embedded in the relevant interests to regulate them. It is difficult to require various institutional actors to act against their own interests. So he advocates in favor of courts playing an important role in positive free speech due to their role in issuing judgments that can have structural implications in various democracies. Andrew notes that courts should not invalidate legislation that supports positive freedoms without interpreting without interpreting it, considering positive as well as negative freedom. Courts should act over systemic malfunctions of a democratic constitution. And as the French case law indicates, media pluralism should be a constitutional value aimed at making free communication more effective. And even beyond these cases, pluralism must allow the representation not only of established social groups, it should include opinions that are not organized or established. I entirely agree with the approach and the substantive argument. I will just contribute to this discussion some thoughts in relation to the judicial philosophy that exists in some states. So whether courts will adopt the role that Andrew suggests depends on their judicial philosophy. We need to consider some elements related to the legitimacy of the judiciary that are different in various contexts. Andrew briefly engaged with these points as well in the book. So what the judiciary is seen as having legitimacy to do depends on reasons that relate to the constitutional equilibrium and the interplay between the three branches of government in various states around the world. These ideas are also relevant to the legitimacy of the government to intervene within civil society. So my reflections aim to emphasize the importance of the book and how it can contribute to reformulating the current debates on the issue. And it is important to study those issues today because in the US, where principally action is needed, because US-based companies define democratic debates all around the world, a philosophy of positive rights did not prevail. Government action in this area is considered to be hindering inventivity and entrepreneurial spirit. Andrew engaged with the relevant scholarship in the US, which emphasizes the importance of diversity for democratic government, which implies that government action is required to enhance democracy. But in the US, the democratic argument and the autonomy arguments in favor of free speech are associated with ideas of distrust towards the government. Courts have used the First Amendment to engage in constitutional deregulation, as Robert Post has noted very insightfully in some of his writings. Case law in the area of political campaign funding, for instance, indicates little willingness to consider the positive aspects of freedom of expression. The US Supreme Court is famous for having noted in Buckley versus Valeo that the concept that government may restrict the speech of some elements of the American society in order to enhance the relative voice of others is wholly foreign to the First Amendment. So if we look at the deeper judicial philosophy dominant in various states around the world, we will see an interesting phenomenon. In states where a political philosophy in favor of government action to help the citizens realize their liberty exists, courts tend to defer to the legislative. It is in states where positive rights are not enforceable that courts see themselves as having an important role. In a general context which treats courts as having an important role, courts see themselves as legitimized to engage in creative interpretations that reflect and bring about social change. But this is the case in systems like the US, where courts see themselves as having legitimacy to intervene and limit what the legislative branch has, and to, more generally, to reduce the impact of government within civil society. In states where it is seen as the mission of the government to intervene and help the citizens realize their liberty, courts tend to defer to the legislative branch too much. So in states like France and Germany, where I think that there is an ex-ante understanding in favor of positive action of the state to help the citizens realize their liberty, and we can make sense from this perspective of the decision by the Conseil Constitutionnel that the recipients of information should be able to exercise their free choice without private interests or public powers substituting their own decisions, without the freedom being made the object of a market, courts are hesitant to do too much. So despite their shortcomings, and as Andrew notes, there are many, these decisions are some indications of some potential for further intervention. But there, the expectation is that action will come from the legislative branch. So states where some conception of positive rights exists are states where judicial review is rather timid. And as Andrew knows, the Conseil Constitutionnel is less precise in forming the area within which politicians can act regarding positive free speech. The Conseil does not clearly recognize a need to frame the legislature's constitutional obligations. And this is because it's different to the legislative, mainly due to its history and judicial philosophy. And this can be traced back to the idea that it is the mission of the parliament to protect rights, as Andrew also notes in the book. The judges do not see themselves as having legitimacy to do too much. They only provide limited guidance to the other two branches. Courts in some states like South Africa have indeed played an important role towards emphasizing the importance of positive rights. And in some European states, during the economic crisis, courts again played an important role in protecting social rights. But this was done in the context of the theory of acquired rights, where the legislative branch had already articulated the need to protect some rights. the court ruled at a later moment that a previous decision of the legislative branch had established those rights. Those rights were now entrenched, and later decisions that are limiting those rights raise some concerns in reference to those rights that have become entrenched in the meantime. So when courts issue decisions like this, they are also dependent on the collaboration of other branches of government, the executive and the legislative branches, to implement changes that they suggest. So maybe the way out of this difficulty could be an emphasis on the collaborative approach between various institutions. Eileen Kavanagh has discussed this approach in a book which is coming out this year, and I think that Andrew's analysis is very compatible with this theory. So even if the judicial philosophy that Andrew advocates for wins over, again, we will need the executive and the legislative branches to take action to implement these principles. And whether they will depends again on their realization of the urgency in implementing some principles of justice. Andrew is right that in the case of free speech, what courts can do is somehow circumscribed. They need to interpret the relevant clauses of the Constitution as including positive elements. Courts only need to be more daring in their interpretation of the clauses protecting freedom of expression. And the most important contribution of the book consists in emphasizing this fact. So unlike other social rights, elements that relate to the positive aspects of free speech can be read easily into constitutional texts in reference to broader principles of democracy. So I would very much like to see the judicial philosophy that Andrew suggests implemented and see the Conseil Constitutionnel articulate as the implications of positive free speech, ownership, transparency, editorial freedom, and public financial aid across media. And the book, of course, makes a very important contribution in this area. And I also believe that future research of scholars working on free speech should focus on emphasizing those principles of justice that Andrew also discusses with great sophistication. Now, I do hope that this book will be very influential and that it will contribute toward change in judicial philosophy, but also in principle, it is important to change the understanding of political actors towards realizing the positive elements of freedom of expression. Thank you.
Well, thank you to Adrienne and Gianni and the Center for organizing this. It's a great pleasure to have this opportunity to discuss Andrew's extremely stimulating book, which I truly enjoyed reading very, very much. I find myself in agreement with most of the book's main claims. So I just outlined the four most important, in my view, Andrew's claims. First, that free speech is a precondition of democracy and that it needs to be interpreted as such, as a democratic freedom. It has other functions or justifications, of course, such as individual autonomy or self-expression, but the role it plays, or it has to play in a democracy, has legal implications that need to be clarified, that are not yet fully theorized, and that should be taken seriously. Second claim, because of this democratic role, free speech has a positive dimension, in the sense that it creates state duties which are not only negative duties to abstain from censorship, but also positive duties to act in order to assist speech, either by protecting against private interferences, or by creating and allocating resources for expression. Third, one of these duties, which is the center of the book, one of these positive state duties is to guarantee pluralism of opinion in the media, and more generally, what Andrew calls plural public speech. Fourth, and finally, positive state duties, such as supporting plural public speech, cannot be fulfilled only at the level of ordinary law. They should be understood as part of the constitutional right to free speech. So the idea being that this fundamental constitutional right generates simultaneously negative state duties and positive state duties, which raises, of course, the question of the Constitutional Court's role in realizing it. The great originality and value in Andrew's approach, in my view, comes from two methodological choices, which are very ambitious. The first methodological choice is to defend such claims, which are normative claims, not just descriptive ones, and so which as such are often addressed or dealt with by a legal or political theory, with the means of comparative law. That is, by looking at legal orders that have recognized free speech also as a positive freedom, in particular in France and Germany, not in order to use them as models to be followed, but rather in order to explore the realm of possibilities which is offered by democratic constitution and to reflect on what could be in other contexts. A second remarkable methodological choice is to build the general theoretical framework for this comparative analysis by drawing on a plurality of fields, not only legal scholarship, but also media studies, political theory, doctrinal law, in order to grasp all the dimensions of pluralism in public speech. So I think it's a very ambitious and useful and much needed, in fact, approach, and that we do need more work going in that very direction. So my comments or questions are all made in that perspective, that is not to undermine the main claims, with which I agree, but to identify some challenges I think they raise and that we do need to tackle as we move forward. So I want to consider quickly, first, potential conflicts between plural public speech on the one hand and other dimensions of free speech on the other. And then second set of questions, potential conflicts within plural public speech between different components of pluralism. And if I have time, I'll conclude with some brief remarks on the French case. So first set of comments. Andrew's proposal, of course, is not to replace a negative conception of free speech by a positive one, but to include both positive and negative dimension within one single general constitutional right. And I think he's right to go that way. But then we also have to consider conflicts that might occur or appear between these positive and negative obligations within this single general right. So when the state, for instance, bans commercial political advertising in broadcasting media, or when the states put limits on media ownership, or when it makes some public subsidies to private operator dependent, conditional on some diversity requirements, when it does all this in order to promote media pluralism, of course, it is limiting free speech in some way. In France, as Andrew explains, the Conseil constitutionnel has considered that by doing this, it is also enhancing free speech, because pluralism is a condition for effective freedom of communication, for freedom of communication to play specifically its democratic role. And in some decisions, the European Court of Human Rights has made some progress in that direction. But in any case, what it does then is that the state, by promoting media pluralism, is limiting freedom of speech on the one side, on the one hand, in order to enhance it on the other. And this is precisely one of the reasons why some theorists and some courts, including in France and at the European Court of Human Rights, have been quite critical and have been very reluctant to attach positive obligation to the constitutional right to free speech, because they do believe that to give equal constitutional standing to negative and positive obligation is necessarily to weaken the force of negative obligations. And so it's to undermine the core value of free speech, which is, in their view, solely the refusal of state censorship. And I think that's a serious challenge we do need to address. So the general question is, how should conflict between various positive and negative obligations generated by free speech be conceived? How should we conceive of these conflicts, and how can they be adjudicated? Andrew mentions in the book that the force of positive obligation is relative, in the sense that they come in degree. So plural public speech should be promoted as much as possible. But is it also the case then of negative obligations? For instance, of the obligation not to suppress opinions based on their content? Or should we accept that positive obligations and negative obligations do not have the same force? Should we consider that negative obligations, or some of them at least, need to be strictly realized, while positive obligations, or some of them at least, should be realized only as much as possible once the negative obligations have been satisfied? So how do we balance them against each other? And I suspect to have a full response to this general problem, we might have to address also something that the book mentioned but does not directly deal with, which is how should we articulate the democratic function of free speech with its other functions? For instance, its role in making individual autonomy or self-realization possible, because those other justifications are likely to lead us to give different weights to various positive and negative obligations. Okay, second general set of comments or remarks on the meaning of plural in plural public speech. It seems to me when we talk about pluralism in speech, and in particular in the media, we refer to various ideas, and they all appear and they're all analyzed at great length in the book, very convincingly. But I wonder whether they might not sometimes be incompatible. Andrew underlines that pluralism in public speech is needed across different media sectors, that it involves diversity of media contents, but also audiences. And he does a wonderful job showing how and where pluralism can be obtained in different ways. But it seems to me the meaning of plural or pluralism is itself plural. It sometimes refers to the idea of diverse opinions, sometimes to representative opinions, and sometimes even to antagonistic opinions or contradictory opposite opinions. And the relative importance of diversity, representativity, and contradiction will depend, of course, on one's understanding of what democracy requires. But in any case, those requirements cannot simply be added together because they are sometimes at odds. So for instance, better representativity may imply less diversity when some opinions are socially hegemonic. And similarly, in order to, if you want to promote contradictory debate or communication, the clash between opposite views, you might have to weaken representativity to give greater representation to views which are unpopular, for instance. Those dilemmas are on the forefront, when the state, in the name of pluralism, decides to allocate limited amounts of time to political parties or candidates in broadcasting media during electoral campaigns, as it is the case in France. Should time allocation depend on the popularity of the party, as measured by previous elections? Should there be strictly equal time to favor small parties or unknown candidates? Should we get rid of such constraints? And these questions reappear at each presidential or legislative election. And I think to answer them, we have to disaggregate the idea of pluralism into several components and try to see how we can articulate or prioritize them. And this issue also arises, of course, because pluralism in the media can be linked to democracy in two ways, and Andrew correctly, I think, accepts both. From the point of view of the speaker, since individuals and social groups should be able to express themselves and be heard. It's the idea behind Pierre Rosanvallon's phrase, a democracy of opinion, which gives Andrew's books its title, but also from the point of view of the public, because citizens need to be exposed to a plurality of opinion. And that was the reasoning behind the Conseil Constitutionnel decision in the 80s. So in the first case, pluralism has to do with fair opportunities to be heard. And in the second case, it has to do with fair opportunities to hear and to make up one's mind autonomously without seeing one's choice being determined by the state or by the market. But here again, I think the two aspects might be at odds, where, for instance, ideological conformity rules, fair opportunities for expression may not lead to a sufficiently diverse range of opinions being disseminated. So to put it in a nutshell, and here, pluralism or plurality may appear as yet to indeterminate and perhaps sometimes contradictory an idea, as long as we don't have a clear view of its components and their relationship. So how do you understand those relationships is my last question.
Thank you so much, Mathias, whenever you're ready.
Thank you very much. Thank you for inviting me. Every free speech scholar and everybody interested in freedom or democracy, I think, should read this groundbreaking book. In his rich treatise, Andrew Kenyon convincingly shows how and why freedom of speech should be understood as a positive freedom of sustained plural public speech in a democracy of expression. As a positive freedom, it demands not only state inaction, but also state action to establish the structures and underlying conditions that enable the formation of public opinion. Unlocking a vast amount of material, from case law over legal writers to political philosophy, Kenyon carefully shows that this does not only hold true for jurisdictions like Germany or France, but even for US writers, like the earlier Jack Balkin, who in 1990 pointed out that radically unequal economic power might endanger free speech. who suggested that the US Constitution might require state funding for public media, and who spoke of freedom of speech as an affirmative liberty for which courts could define a range of alternatives for the legislature to pick from. So the idea of a positive freedom of speech might not be so foreign after all, even to the US discourse. The current US Supreme Court should listen to those US scholars who have long since argued for an understanding of free speech as a positive right, although this court's majority now seems more inclined to continue to weaponize the First Amendment instead for a libertarian marketplace of ideas, in which not the argumentative force of those ideas, but instead money becomes the decisive currency for the marketplace. In the handbook, Oxford Handbook of Freedom of Speech by Stone and Schauer, another indispensable resource for comparative constitutional lawyers published last year as well, Kenyon highlights the democratic rationale of his books. As always, but especially in this case, you have to read the book itself. The payoff is enormous because Kenyon introduces us to the material on which he draws in a clear-cut, concise, but thorough fashion. Kenyon will hand you the keys to a whole universe of literature and case law. I will focus my remaining remarks on 2 points. The first and main point is the book's, to my mind, exemplary reception of the German Constitutional Court's case law. The second point will be the suggestion to deepen the connection of this approach to equality and autonomy, or maybe to human dignity as well. To the first point, German constitutional law on broadcasting freedom. To be sure, of the book's 8 chapters, only 1 deals with it, some 30 of the 250 pages. Another chapter deals with France, and as Kenyon points out, other jurisdictions acknowledge comparable obligations as well. For example, Argentina, Japan, Italy, the Netherlands, Portugal, and Spain or India. But it is apparent throughout that Kenyon has acquired a rather intimate knowledge of the long-standing German case law and on the literature in English. As he demonstrates, this case law neatly fits into a larger international body of thought. Kenyon's description of the German case law is thorough, precise, and accurate. For German comparative lawyers, it is remarkable and might also be useful to know that his analysis seems to rest, for the decisions older than 1999, mainly on translations provided online by the Institute for Transnational Law at the University of Texas. The Constitutional Court's case law on broadcasting now spans more than 6 decades. Since its first decision from 1961, freedoms was already laid 3 years earlier in 1958, the Lüth judgment, which established the indirect horizontal effect of freedom of speech. As became clear later, this horizontal effect is at least partly derived from a general duty of the state to protect fundamental rights against dangers arising to them from private parties. The court puts individual and collective formation of public opinion front and center as the central purpose of all communicative freedoms. These freedoms require state action to create a positive order, ensuring that the whole variety of existing opinions is expressed, or, as Kenyon puts it, that speech remains plural speech, reflecting a diversity or multiplicity of views. To safeguard media pluralism is therefore a central command of the communicative freedoms itself, not something extraneous to them. The court assumes that an unregulated economic market will not necessarily provide for such pluralism on its own. Audiovisual media in particular have a special reach, timeliness and suggestive force, Breitenwirkung, Aktualität and Suggestivkraft, that makes such market failure more likely. Media businesses therefore are not to be treated like those selling toasters or paper newspapers. As Kenyon stresses, and as a younger Balkan has pointed out independently, the positive dimension of freedom of speech generally only sets a constitutional frame for the state, while leaving discretion to fill that frame. It prescribes only the goal, but leaves a wide range of means to pursue that goal. In its recent judgment on public broadcasting fees of August 5th, 2021, the court has forcefully renewed its commitment to such positive constitutional obligations to secure a communicative infrastructure of plural speech and avoid domination either by the market or by the state. In the handbook, Kenyon points out that the internet does not ameliorate the need for diversity of speech, which is a fine understatement. If there have been any doubts about the destructive potential of the web's many-to-many communication for democracy, they should have been put to rest by the attack on the Capitol on January 6, 2021, and by the role the 45th president played in encouraging it as a hate speaker and disinformant-in-chief. Online through his Twitter account until the company finally pulled the plug, but with the help of traditional mass media as well. My second and much shorter point regards the connection of positive freedom to the values of equality and autonomy, or even dignity. I think this connection might be strengthened in Kenyon's approach. The egalitarian side of free speech has been highlighted especially by feminist authors warning of the harms of silencing and subordination. Germany, in this egalitarian side, has a strong foundation in the case law as well. The Lüth judgment pointed out that public opinion arises out of the contestation of opinions brought forth in equal liberty, im Widerstreit der in gleicher Freiheit vorgetragenen Auffassungen. And the diversity or pluralism that the communicative freedoms demand is a diversity of equal weight, gleichgewichtige Vielfalt, according to the German Constitutional Court. The democratic foundation of the freedom of speech might, moreover, be connected to autonomy and dignity as well. Participation in the formation of public opinion and ultimately in the formation of the political will of democratic self-government is not something separate from self-realization and self-development, but a central element of them. Private and public autonomy are co-original, gleich ursprünglich in Habermas' words. See also Daniel Allen's work. The German Constitutional Court has, especially since 2009, acknowledged as much, since it regards the democratic right to equal participation in the formation of the public will as rooted in the right to dignity. Thank you very much.
Thank you, Jacob, whenever you're ready.
Okay, thank you very much. And thanks for inviting me to participate in the discussion here, for the chance to read Andrew's book. I think it's an incredibly important book. I'll explain why I think it's important, and then I'll move on and make a few substantive comments about the thesis. So why do I think this is an important book? I think it's really important. Well, first of all, there's a work of scholarship, the sheer breadth of the analysis here. Yeah, Andrew locates the issues of positive speech rights within constitutional and political theory, engages with the scholarship from a wide range of disciplines from various different jurisdictions, and also looks at the detail as well, particularly with the case studies from France and Germany. And if my reading of the book is correct, it seems like the system in Germany is to be taken to be the closest thing to a role model for the protection of positive speech rights. And to bring all this together in a single monograph in a way that's clear, accessible, closely argued, I think that's a considerable achievement. So I think it's a really good work of scholarship there. Another reason why I think it's an important book as well is, well, certainly in the UK, I don't know about in other jurisdictions, but in the UK, it feels like the free speech debates are often very heavily influenced by the American scholarship. And there's pretty good reason for that. They've had a lot more years of, free speech as a legal or constitutional issue, and they've got more legal academics who are writing on these things. So often, some of the debates that have been taking place in the US are a starting point for our discussions as well. But that raises a few hazards. It means that free speech theory is often fused with American constitutionalism and the First Amendment in particular. And there's always a risk that by engaging with these debates, we start to import certain features of the First Amendment into our own analysis. And what I think you do in the book really well is that you engage with the US scholarship, particularly that that's been critical of the US tradition. But I think you develop a theory that is, better fits certainly with the experience here in Europe. So it kind of helps to unpick some of the issues and take it away from some of the concerns that we see with the First Amendment. Another reason why I think the book is important is underlining the scope of free speech and that positive dimension. So a lot of the book, in looking at the positive sides, are looking at areas of media law. You're looking at media plurality and looking at public service broadcasting. And I think a really important thing that comes out from the book as well is that these are not simply matters of government policy. These are not simply things that government can do because they think it's nice to do them. These themselves are part of the fundamental right to freedom of speech. So we've considered some of the examples of this in the discussion so far, where I think, Charles, you were saying that there might be a media regulation that's passed to advance the positive dimension of freedom of expression. Say, for example, one that might promote plurality or rights of access, but that in itself can constitute a limit on the editorial autonomy of the media organization, right? So you've got that tension there. And I think the value of this is that we don't simply see this as an area of government policy that happens to infringe or limit the negative aspect. It is in itself a component of the right to freedom of expression. Now, Charles, in your comments, you were explaining how that is, a complex matter. Once we open up that issue, we get all kinds of, complexities and difficult balances to strike. But what I think is important from Andrew's work is to emphasize that we shouldn't prioritize one over the other. It shouldn't be the case that the negative is prioritized to the exclusion of the positive. And I think that if so, I mean, that's one of the problems that Ioanna was referring to as well in her discussion of the US campaign finance law, where, in the US, you've got that the idea where they prioritize the negative aspect of free speech. So you can't do things like regulate media or regulate campaign finance. So I think it's an important work because it's showing how this is another component of the right to freedom of expression, the positive aspect, and, it has to be given consideration and shouldn't be outweighed by the negative. Obviously, the negative is still important, but there needs to be some way to mediate between the two. So those are some of the reasons why I think it's a very important work of scholarship. I've got some comments also just on the substance of the book as well. I mean, a lot of the book is focused on broadcasting law, and that comes up particularly with the focus on public service broadcasting in various parts of the book, and that very much fits with the approach taken under the European Convention on Human Rights, where the court has, really emphasized that close connection of the positive obligations, particularly those that arise in elections, with the role of the broadcast media. Now, as a short-term point, this is incredibly important at the moment in the UK because public service broadcasting is facing something of an uncertain future. In the last couple of weeks, we've had the government in this country saying that they're planning to privatise Channel 4. Channel 4 is one of the public service broadcasters. If that gets privatised, I think the worry is that then it won't continue to have the various public service obligations attached to it. So that's one issue. You've also got a longer standing tension between the government and the BBC, where there have been various government officials criticising the BBC's political coverage, and there has been various discussions about their future funding model, maybe as a kind of veiled threat, or at least undermining the stability of the BBC in the future. And I think the book deals with this very well, and it raises the question of whether or not we should have some legal or kind of constitutional guarantee of public service broadcasting. So at least it has some kind of stability in its funding and its organisation, and so that it's relatively free from the risks of political interference. So that's kind of why I think the book is actually really important for short-term debates in the UK. But also, I mean, there's a longer term point as well within this. And I think it's that we're at a very kind of pivotal moment here with things like public service broadcasting and public interest media regulation. And that's because that public service, public interest type regulation has very much been associated with the broadcast media. And what this suggests then is that, is there a risk that if the status quo remains, if it's just focused on broadcast, does it get made redundant or marginalized as more audiences move over to streaming and move away from traditional broadcasting? Now, I think, again, you refer to this in the book where, you know, by grounding this not as a technology argument and not as a broadcast argument, by making it clear that it's a democracy issue, it's saying, well, it should evolve as people's viewing habits change. I think one of the big challenges, though, that we've got is how do we take that model of public service media, public service broadcasting, and how do we ensure that it continues to evolve as people's viewing habits change and as more people move to digital media and the streaming services. This is one of those problems that I think we've been able to foresee for some time. For the last 20 years, people have been talking about, you know, what about when audiences move online? But I really think it's happening now. So I think it is going to be something that we're facing, you know, quite soon when we're looking at the future of public service media and public service media regulation. So that's the first substantive comment really is on that focus on the broadcast media and what the future of that, what that means for the future of positive speech rights. Second comment that I've got is really, I guess, a question, and that's about the scope of the positive speech rights as well. Because again, in the book, you're discussing media plurality and public service broadcasting, but these are kind of different because what you're looking at in those cases are the protection of certain institutions and stable arrangements for those institutions. What you're not doing is saying there's an individual right where people can claim a certain portion of speech resources that's enforceable by courts. So media regulation is slightly different. But of course, if we develop the positive side to freedom of expression, then there can be individual rights that arise. So one example is, say, the right to freedom of information, where an individual can bring forward a claim and say that they're entitled to hold government entitled to access government held information. But this could be developed to various other individual rights as well. So there's a question of whether positive obligations for speech entails protection for whistleblowers, so they don't suffer adverse consequences from disclosures. We might also say, does positive speech also mean that employment law should be changed so that employees aren't subject to adverse consequences by their employer for exercising their speech rights? Then there's also questions about whether protesters or speakers should have access to privately owned lands, say, privately owned shopping centres and so on, if that's part of the substantive or positive aspect of freedom of speech. And I guess the challenge is there are lots of things that are quite nice for people to have for the purposes of speech. There are lots of things that are helpful and which facilitate expression, but which of those things do we say go into the fundamental right? Which of those, do we want to constitutionalize, and which are just left as a matter of government policy and for government to choose to provide if they want to? And I guess it's that question of, once we open up the positive speech obligation, once we go down that path, what's the stopping point? How far, what does this entail? Final substantive comment is about the question on the role of the courts. I always raise this whenever we talk about positive speech rights and say, what should the courts do? And so we've discussed that, and that's gone into the book. But I think I agree with the line of argument in the book where you say, there's a problem of just leaving these things to the political branches, because you've got problems of political inertia, and you've got kind of problems of potential partisan misuse of power, or, exercising legislative powers or executive powers for partisan advantage. So for those reasons, you say you need some judicial input into this. I guess my question this time is just a little bit different, and I'm just wondering, do the courts really have any interest in pursuing this? Do they actually want to pick this up? And the reason why I raise this is that I was reading a case a couple of weeks ago from the English courts about rights to protest. And it was one about, they considered, does Article 10 entail an access to privately owned land? and the court were just absolutely clear. They were quite dismissive and said there's no right to a forum. Article 10 does not include a right to a forum. And I was just thinking, why are they reluctant to go down that path? And it might be some of the complexities that Charles was referring to. If you go for the negative approach, there's kind of a simplicity with, or at least I don't think it's that simple, but it might seem more simple. It might feel like you're opening up lots of difficult questions if you go down the positive path. So I'm wondering really, is there anything that can be done that might make the courts more willing to kind of engage with these issues when they potentially arise? Okay, thank you.
Thank you very much, Andrew. Plenty of food for thought for you there. The floor is yours.
Thank you very much, Adrienne, and look to all of you. It's really rewarding and pleasing to hear such comments from a great range of speakers. I'll try and run through and offer a few thoughts on each of the comments. I might offer the sort of avoidance one of that's a really good question and it needs sort of work, but I'll try to not do that too much because some of them really were good and important points, which I've thought about and didn't quite know what to do with in the book. So, but let's start with Ioanna. I think raising the sort of understanding of the role of courts, parliaments, and executives within a particular state is really important. And you see this obviously in constitutional law and in comparative constitutional law models, but also in media studies. So one of the works I cite a bit in passing is Mancini is one of the authors. I just have a blank on the other, terrible. A classic study of comparative media systems and democracy. And they don't really engage with these aspects, but explicitly, but they label them all under the attitude to the role of the state. Right? And so you see that most clearly between European models and US models. Is the state helping to support people's ability to live a full life, or are they going to do that in the US model by avoiding limitations? And I think the role of judges is clearly an important part in that. I mean, I would agree that I don't think US courts are likely to run with this anytime soon, which was your point. I mean, they've had members that have come much closer, and so Stephen Breyer is one where he's written things on active liberty that go broad parallels. And I think one of the reasons I try and talk about some of the older literature at such length, largely older, but not only, is to point out there is a tradition of analysing US requirements of democracy and of free speech that would support this. And that's useful, I think, as was mentioned later, for the comparative use of US writing and case law. I think I said at a few points in the book, but possibly didn't say enough, because I'm not sure anyone brought it out as much as I tried to. And it's understandable because I talk about courts at great length. I said a few times, well, courts got real limits. It depends on how the actual model of the court in question, how a judge is appointed, what's their term, who gets access to go to court, et cetera, right, within the constitutional model there. And also recognition, which I'll come back to at the end, which was Jake's point about, will they actually want to act? But noting those limitations, I also noted the limitations of the others, which implicitly gets to the point I think that Ioanna, you're talking about in what you're doing, which is about the collaboration between the arms of government. A collaboration that might sometimes be a little conflictual, or it might not always be perfectly harmonious, because it is each of them pushing to get an appropriate response to the constitutional requirements, in this case for the rights of free speech. Let me move on. Thank you for your summary, Charles, of the main claims. I think I understand my main claims more clearly now than I did. I agree with what you said about them. And look, the challenges I think are all there that you raised. So the first was about conflicts between positive and negative dimensions of free speech, so conflicts within free speech. And this is an area I know you've worked on in terms of internal conflicts within the right, and I think it is a really interesting area and way to approach free speech analysis. One short answer Jake gave later, which is that understanding that free speech is relevant to both aspects that are being considered actually changes the analysis. It doesn't preordain any result, but it provides a different grounds in which to argue. And I think just doing that is quite significant. And if anything, what I'd hope to achieve through this bit of work on positive dimensions of freedom of expression, and maybe others do similar sorts of work and build on bits, is just to say approaching an analysis in that way is quite ordinary. Right? And there'll still be arguments, oh, well, the balance should end up here or it should end up there. But we're talking about it in a different terrain. And I just think overall that would be quite productive and useful. So I don't know that I'd say there is a clear, necessary hierarchy between the rights. There is a difference, I think, between them, which I try and bring out using some of the German writing, more of the analysis, which is just the difference between how you approach a limitation and an obligation to act. In that, and this is quite, there's a lot of debates on this in relation to the European Court, more generally about their positive obligations work, which is that every limitation then has to pass through the appropriate constitutional hurdle. So let's say, is this limitation necessary in a democratic society, etc. That sort of test. Oh, there's a limit, we apply a test. It may be allowed or it may not be. Whereas if there's an obligation, your obligation to, in these sorts of areas, you're after a state of affairs of, I've called what I've labeled sustained plural public speech. And there's no one particular act that reaches that state of affairs. And even in relation to improving it in a particular jurisdiction, there's any number of things that could be done. And so that is a difference. And the question is, in which instances should which decision maker make that judgment? I don't know, sometimes it may be courts, sometimes it may well be parliaments. And the final chapter in the book is called Framing Communicative Freedom. Quite intentionally, that my understanding of the German approach, and to some degree, that's a model, as Jake suggested, is it does, claims, it does leave a lot of room for parliaments to then work out what they're going to do. And that's quite appropriate with positive obligation. So that difference between the positive and negative dimensions of the freedom sometimes helps resolve the conflict, sometimes. That said, sometimes you'll arrive at them directly where you say, you're restricting this media company's freedom, but you're doing it for this end. And to that, I just really come back to Jake's point, which is, yeah, but then you're understanding free speech reason that you're doing that. Second one, the meaning of plural. I really like your comment on this. Different versions earlier in writing this thing had different words there for plural. I wasn't really quite happy with any of them, but I stuck with that one. It just seemed the best overall. It is meant to encompass a range of qualities, as you drew out: diverse opinions, representative opinions, contradictory opinions, and sometimes they could be incompatible. And I think my response to that is, my argument is that a democratic constitution entails an obligation to positive communicative freedom, but that isn't only one model. It means, and there wouldn't be only one way of allocating or resolving the tensions between those different aspects of pluralism, but it needs to be a reasonable one, and it will be argued about in analysis and perhaps in legal argument on those terms. And again, doing that is a bit different. One of the ways that I attempt to respond to that as well is a lot of the focus that I've had on trying to describe what I think sustained plural public speech would be. It does talk about the content a bit, it does talk about the speech, but a lot of it is talking about the structure. And the structure and the actors, both in terms of those who create it, who distribute it, who fund it, and who listen to it, and trying to, or receive it, trying to get diversity in that actually leaves some of those decisions about, are we emphasizing opposition and contradiction here, or are we emphasizing representation, to those different entities? And I just think that's more likely to arrive at a model that doesn't infringe negative aspects of free speech as much as direct government sort of goals of, you know, do this and do that, right? So that's the sort of, and so it's almost like sometimes I think, you know, democracy and communication in relation to democracy is a lived experience. And so it happens over time, it happens through different groups and actors acting. And so there is no particular ideal model that you can arrive at. You just get closer or further from something that looks sufficient. Yeah, but all of that said, I first chose the term pluralism thinking it was probably a bit indeterminate. Oh, I do appreciate your comments. Matthias, thank you. I hope everyone reads it too. I should note, when Adrienne and I were first talking about this seminar, we were sort of like, US, Europe, US, time zones are terrible in Australia. Unless the both of us wanted to be up at 2 a.m, this was not going to happen unless we looked at Europe. And it's great, it's really good. It's recorded, so maybe some people in the US will watch it and think, oh, what's this weird thing they're talking about? Because I think, well, I'd hope it'd be great if some of the ideas got talked about there. As you noted at some length, Mathias, around things like Jack Bolton's earlier work and a whole range. Now, and as might have been implicit in some of the comments, for the French chapter, I used a lot of French resources, and because I have sufficient French to do that. For the German chapter, I didn't. It is very comforting to have an analysis. I did talk to some German academics along the way and checked a few things, but it's very comforting to have an analysis that says, no, look, it's a plausible argument. It's a way to understand the judgments. Some people might argue other things, but it's sufficient and hopefully useful for English language analysts to make a bit more of what's being done there. I also was very reassured when at a different event where we were talking about other things, Mathias mentioned the 2021 decision, which sort of happened after the book was in press. And I was very pleased to see the court didn't abandon its approach, but it is maintaining it. And that comes to something I'll come back to with Jake quite soon, which is around the sort of challenges for the future and the changed communication environment. One of the other things I'd observe is I think probably Ioanna, Charles and Mathias anyway, there was quite a bit there on equality of speakers, and in the comments, either that's sort of in there implicitly in what I've done or in ways to extend what I've done. And I think it's probably a bit more implicit than it maybe should be in what I've done. So I appreciated hearing that. And it does come back, I think, in some ways. Hold on, let me think about that. No, look, I'll leave that. I think there is something to do in that, and it's a little bit like the comments I made in the response to Charles a minute ago, which was, to some degree, I move that issue off to a structural approach around diversity of actors, which will provide a model of equality, of freedom to communicate, but one step removed from trying to get any further, simply because of a difficulty of working out how you would take that further. And maybe someone can do that better than me. Now let me get to Jake. Yeah, as I've noted before, thank you for answering Charles's question. That was very helpful. Yeah, look, I've wondered about both the medium-term debates in the UK about, or the recurrent debates in the UK about the BBC, and the very, very contemporary ones about Channel 4, is whether these sorts of arguments or analysis that I offer would get any traction. And so that's something we might come back to when we get to discussion, because I'd obviously see the connections, but I just sort of, I think the reason I had doubts was, I think if they were raised in Australia, they wouldn't get much traction. And you could raise similar things about both the ABC, which is a sort of mini BBC model, and SBS, which is a multicultural broadcaster, largely commercially funded, but a public broadcaster, so somewhat closer to the Channel 4 model. But the longer term point you raised there, which is how to translate this model, is absolutely right. And I get towards that at the end of the book, and I say a couple of things and not that much. One, because I'd worked on it all for far too long by the time I got to that point, but also because I think it is, I wanted to get those ideas out as a set of ideas and model, and for people to think about, and then for myself to be able to find some time to say, well, okay, so what would that be, right? And it raises a whole lot of issues about the role of internet intermediaries, so the major platforms, the distribution becomes a much more significant issue, and that raises issues of regulation that are quite distinct, because they're even less state-based in many ways than the traditions of broadcasting. So yeah, look, I agree. The scope is something, and I think I missed this with one of the earlier comments, maybe from Charles as well. You know, what's the scope of the positive speech rights? And you're right, I do focus on what I call a sort of structural aspects, and in some sense this arose because of the case law I ended up focusing on, because in those two cases there's a degree of that, and it makes sense to me that that is an aspect. I said at various points, of course there are many other implications, and I listed a few, and other work I've done with colleagues and or edited of other people's work, note some of them, like you said, around FOI, around access to privately owned lands, etc. The examples you gave, I was thinking, you're running through the European Court of Human Rights. You know, they're all just about, I think, just about all issues they've dealt with, either finding potential under Article 10 or going, well, not in this case, although often saying, oh, but it could have arisen. So I'm thinking about one of the access cases where they said, well, here you didn't have rights to this shopping centre of access, but because there were many other ways. So it was a bit like a time and manner restriction on a demonstration. That's okay because it's not a complete ban. It was that sort of model. One thing I should probably say about that is, I note briefly, and this was a comment really Adrienne helped me clarify early on, which was, you know, what do I mean by right? When people talk about free speech, and there's different sorts of rights. And you can mean, and people often do just automatically mean, US writers particularly, I think, a right enforceable by an individual in court. That's a right. If it's not that, it's not a right. Whereas some of the approaches to positive dimensions of free speech talk about, in effect, it's an obligation on Parliament. Now, that could be, as it would have been traditionally under the French model, entirely for Parliament, and then gradually the Conseil Constitutionnel's got to be involved and said, well, hold on. You can't do that, or you have to try and meet this. And the German court has very much done that, has said the set of obligations. But that's still a form of obligation that may be enforceable in a way. One of the questions that raises, and maybe particularly for common lawyers, is who gets to bring a case about what? And most of the cases that have come up that are talking about this are either media companies or NGOs around like the FOI type stuff, that side, where they haven't had access to something they feel they should be able to, or they're media companies, like in the German case, where the public broadcaster says, we haven't had enough funding. And they can go to court and they can get it corrected. I mean, that's, can't quite see that running in the UK. So that is a real question. But again, although the examples are very much looking at instances where courts have done it, and in part that's because you then see the reasons why they act and the sorts of things they require with a bit more clarity than what happens to have arisen through a policy process. You could achieve those things, in theory, through government legislation. You just face the conflicts of interest type aspects that politicians might well face, which might limit how far they go in this direction. So I'm sort of coming in a long way around to your question, Jake, which was around, what's the stopping point once you start talking about positive dimensions of free speech? Which ones are constitutional, because lots of things could help, and which are left to government policy? And there's a couple of answers, and one of them is simply the difference between a negative dimension and a positive, which is that if you're focusing on these structural aspects, you'd say it's a situation which has sufficient plural public speech, in my words, is what's required. You could do that in many different ways. Government can decide. But what they've done here is they have set up a board that's looking after a particular media entity that's not independent, that's, et cetera, et cetera. And you'll see even the European Court of Human Rights has had cases like that, where you've had a very dominant public broadcaster in a particular country that's had really poor legislative controls in those terms. A non-independent board effectively subject to government control. And they've said that breaches Article 10. But it was in pretty extreme circumstances where that court has said something like that. But so one part of the stopping point is simply what's set as the goal and what's required in terms of the particular actions. Could be a division of roles. And with the others, it's probably a bit like lots of legal arguments about slippery slopes and things. I mean, somebody's going to make a judgment and say, look, this is in, this isn't. You don't need perfection in this. Some rights will be too far-fetched or inefficient's not the word I want. It would be sort of so much would be required to achieve that for a limited benefit, that sort of thing. Now, the role of courts, so I'm glad I've convinced you in part that politicians aren't great either. My book is in some ways perhaps a depressing analysis of why none of this will work very well, but in a scholarly fashion, of course, as you kindly all said. But I do really like the point you ended with, Jake, which is, do courts actually want to pick this up? And I think maybe often not, and part of that because it does seem complex, and part of that, just as you implied, is because lawyers aren't used to the argument and the analysis. Because, nobody would say the First Amendment case law is simple, or that the doctrines and analysis under it is simple. Just looking at the negative dimensions, but there's a huge literature on it. People are schooled in it. They're used to the general ideas. You can go with it. So one aspect is simply familiarity, and that's both in terms of what scholars write, or academics, how they approach the issues, and also the arguments lawyers present. And they might, I don't know what they presented in that, how they presented the argument. And of course it might get refused, but if it's in the literature and gets well presented, there's a possibility. The other aspect is in doing that, and I think both the literature and the court-based arguments, it's finding ways to show that it isn't necessarily so complex. or so open-ended. It's simply saying requiring X will be an improvement on the current situation, a meaningful improvement, and it's doable. So what's the problem? Why would you not do that? So that's the sort of argument. That said, to come back to where I started with Ioanna, Brea was sort of a minority of one for decades, and he's probably now a minority of zero, on the Supreme Court. So the challenge there is real. Look, let me just finish before we move to general discussion, is to thank you all again. It's really nice to think academics all around the place have read this work so closely and have come up with such really useful comments to me on it. And I will look forward to maybe finding ways to speak with each of you again about that in some way or other as our work develops. Adrienne, I think I've said enough. I should hand back to you.
Thanks, Andrew. That was wonderful, and thank you to the panelists for that interesting discussion. So I would like to facilitate a discussion amongst us, and I might just begin with a provocation for you, Andrew, and something I'll throw to you initially, but on which I would then hope that the other panelists will join in. So my provocation is twofold. It partly stems from my perspective as a comparative constitutional lawyer, which gives me the intuition that the idea of positive free speech seems to me to be widely agreed upon amongst this group, but I suspect it would be it would be appropriate to institutionalize it in very different ways in different places. So I think there has been some discussion about the comparative role of, on the one hand, courts and legislatures. But I would also think that as constitutionalists, we need to think as a much broader range of institutions. So I would add something like fourth branch integrity institutions. Electoral commissions seem to me a very important instance of a highly relevant fourth branch institutions, as would media watchdog organisations. I would like to add to it, drawing on Vicky Jackson's work, the idea of knowledge institutions, those institutions which provide us with the epistemic infrastructure for democratic discussion, in which she numbers among them things like government offices of science, the press, I think she says is a knowledge institution, and one that relates particularly to my own work. Of course, I regard universities as institutions that provide us with important epistemic infrastructure for democracy. Of course, we'd also have to look at civil society, and broadening it even further, we'd have to look to some extent to the private sector, especially at the big speech aggregators, right? The Googles and Facebooks of the world. Now, once you start broadening this idea out as wide as that, and here's my second provocation, I think it is very useful to say our overall question is, what does a democracy of expression look like? And how would we, as constitutionalists, arrange those institutions to achieve it? The provocation is, I wonder whether we ought to equate that with an idea of freedom of speech. I actually think freedom of speech, even if we conceive of it as having both positive and negative dimensions, is really only part of the story of what a democracy of expression looks like. And so I really think the really interesting idea here is what's a democracy of expression? One question would be, how does freedom of speech, conceived as a right, broadly understood, maybe I don't want to necessarily, I certainly wouldn't want to equate it with negative freedom of speech, and I certainly wouldn't want to equate it with judicially enforceable freedom of speech, but it seems to me only one of the things that you need to get a true democracy of expression is a capacious free speech right. So, two provocations. Should we drop the free speech part and focus on the democracy of expression part? When we do that, wouldn't we see, vastly different institutional arrangements in different places?
Thanks for the provocations. Let me try a few quick thoughts in response, and then let's hand it over to others. Look, I think I would think yes, there's clearly ways to institutionalize this approach in different ways in different contexts. And again, I note that in passing. Other work I've done on with Nordic scholars talks about that a little bit more in that example, that context. And yes, you would come to a wider range of actors, electoral commissions, etc. One I do talk about at some length in the French example, and I mean, depends what you include as the standard model or not, but is there sort of different models of regulators and the actions they have? And in part, I had to do that there because the court's less prescriptive, and then Parliament actually doesn't say that much, and it just repeats the court's words, to be a bit simplistic, and then a whole lot gets left to the executive or the regulator. But that's still in fairly traditional entities. But I think the role of a regulator in the different contexts could be quite important and could differ quite a lot. So just to note that in. But absolutely, knowledge institutions, and I was sure you were going to get to universities, because of course I agree with you about the resources that they can provide and hopefully do provide. I mean, the other way to respond to that in general, and it may relate to the second point as well, is democracy doesn't just need speech. So it doesn't just need communication, but it does need that. And it does need many other things around the actions of electoral commissions, around the interests of individuals and their activities, etc. I think my response to the general point would be yes, but at first there's some real value in talking about it in free speech terms to try and make sure that more people might recognize those dimensions of free speech, the freedom of expression. And I think you're right, the implication of that is there's a whole lot more involved. But otherwise you run, I think, the risk that the constitutional dimensions of it might get underplayed. And again, maybe that depends on the context you're in, the constitutional context. So maybe I'm worried about sort of US free speech model, which would then end up sort of trumping other interests, other aspects. But I do really like your provocation about what does a democracy of expression look like? And that, of course, it requires not just negative and positive dimensions of speech. And I say that at some point in the book, but then I do choose just to focus on the negative and particularly positive dimensions of free speech as then a really important part of it. And in that way, the democracy of expression term, which, as Mathias, I think, said, I forget, or Charles probably said, borrow from Pierre Rosanvallon, is used because of the really commonplace and important connection drawn between free speech and democracy. So that's why I want to emphasize, well, if you're going to link that, you need to link this aspect. You need to take account of these aspects, not only the negative. I'm not sure, I feel I haven't answered your query, but there you go.
Was intended to provoke. Let me invite the other panelists to join in or to introduce a new topic of discussion. Mathias.
Thank you very much. I think I would answer the provocation, which I like very much, with pointing to the climate judgment of the Constitutional Court of Germany from last year, where the court said there's a right to intertemporal freedom found in the German constitution, and which obliges the legislature to plan ahead of 2030 for the climate reductions. So I think in a comparative perspective, this must seem incredibly far-reaching and impossible as a role of the court, I think, and of course it is criticized as well in Germany for that. But what I like about the book is that Kenyon presents possibilities and tries to enlarge. And I like what Charles said. I think he tries to enlarge the sense of possibility. And even if you accept your provocation and choose a much smaller role for courts or for constitutions in a democracy of expression, I think even having shown that this is a possibility to read freedom of speech is invaluable for the discussion, because it changes the terms of the discussions if you consider this possibility at all. Maybe I can add one other point to what Jacob said. I think he thought about a constitutional guarantee of public broadcasting, and I think the main point of the book is that maybe you don't even need an explicit constitutional guarantee to interpret freedom of speech or even the democracy aspect of a constitution to include such rights, such as the Constitutional Court in Germany did. He didn't have much of a textual basis for that, and just developed this obligation to fund public broadcasting media from the general terms of broadcasting freedom. To the question of the stopping point, I would say that the court says, first and foremost, the freedom of speech remains a negative liberty. So there's kind of a hierarchy built in, but not in a strict sense, of course, but in a sense of protecting some essence or absolute core of negative freedom, which cannot be overridden by positive obligations. So there's some stopping point, I think, built in that regard. Thanks.
Oh.
Yes, well, I fully agree that, of course, something like a democracy of expression would require much more than just even a very strong constitutional free speech right. That's completely certain. But at the same time, I'm not sure you can go without such a strong, inclusive constitutional right to free speech with both positive and negative dimension. On a general level, as a political philosopher, I worked for years on deliberative democracy, which is basically obsessed with creating a democracy of expression, before coming to legal questions about freedom of speech. And a systematic limit of those debates is that as long as they stay, as they don't consider the question of the kind of legal framework and communication law, they tend to end up with very interesting but mostly moralistic models of what society should look like, which end up being toothless quite often. So this does not mean, of course, that if you need some kind of legal framework to create powers and possibilities and incentives and controls, this has to go through the specific lens of free speech right. And to a certain extent, it was instrumental in the French case to use Article 11 of the 1789 Declaration. They were looking for some kind of constitutional grounding to justify putting limit on media ownership, because there was a big empire of newspapers and radio and television, the Ersan Empire, which was seen as threatening the French political process. And so maybe it could have gone through another point of entry. But at the same time, I don't think, at least in the European context, it's just about, as someone mentioned just before, a symbolic importance of associating positive dimension with the free speech right. Because in constitutions where some rights, such as free speech, do not only apply to public authorities, but also apply to a certain degree to private actors. In states where you have, like, as the Germans say, horizontal effects of constitutional right, to include in the constitutional free speech rights considerations about pluralism, for instance, is one of the ways in which you also try to regulate what online platforms are doing and what newspapers are doing, and so on and so forth. So the two are not disconnected when you have where you have no state action doctrine, to put it briefly.
So we're really just about at time. Andrew, I see that you want to come back in, but I think I might just quickly ask Jacob and Ioanna if there's something they want to say, if you wouldn't mind being as succinct as you can be. And then Andrew, I'll give you a very short last word. How about that? Ioanna?
Yeah, I have a comment from the perspective of the comparativist who knows the difficulty that exists, especially in transatlantic relations. On this topic. So my sense is that in Europe, there is some willingness in accepting positive rights in the area of freedom of speech, right? So we see we're not entirely happy with the case law that exists in France, but comparatively it is well superior to what exists elsewhere. So I think that only regionally then, if France, Germany could create a current in Europe in favor of recognizing positive free speech rights and possibly also affect EU policies, then you can come up with a regional policy which you would hope might be influential, also more broadly and more globally. And something like this is already emerging, as Charles also noted, in the regulation of all those platforms, Facebook, etc., that are operating globally. When they are regulated in a part of the world, then they themselves change the standards in order to adapt to the regulations existing in these parts of the world, and then treat the rest of the world also differently. And this is what the EU has been trying to do also in the area of privacy law. So maybe if a strong front in this area emerges in Europe, I would like to hope that it might be influential more broadly.
Thank you, Jacob. Can you be quick?
Very brief, yeah. Okay, I agree entirely that free speech can't answer every question. Obviously, there's a big role for knowledge institutions, the media, universities, and so on. I guess the free speech is still important. Two respects, depends on what the scope of free speech is. Do you also mean it includes academic freedom and media freedom, as opposed to a narrow kind of individual right? And also, even if we're looking at the institutions like universities, free speech is also an important principle. It regulates that relationship so you don't get partisan or political interference, and it helps to defend the autonomy of those institutions. So free speech can't answer every question, but it plays a supportive role. And then I'll be really brief on the question of institutions, fourth branches, and so on. I agree entirely with that. I think often when we're looking at the positive aspect of free speech, you're not entitled necessarily to a particular outcome, but you will be entitled to a certain type of process. So to give you an example, when we're looking at BBC funding, you might say, well, you're not entitled to a specific amount of funding, but it should be a procedure for deciding that should be determined by some independent institution. So that's a way of kind of not making it a positive entitlement. We're looking at the process for decision making. Thanks.
So Andrew, it should be simple for you to respond to all of that in about 30 seconds.
I agree. I forgot that something I wanted to say to your original provocation, Adrienne, which is I think implicit in some of those comments, is one of the benefits of what you've suggested, which is thinking more broadly, is where in a particular jurisdiction, one more legal avenue looks a bit blocked. There is actually ways you can use the ideas elsewhere on these other potential actors that can help. And that's also, I think, can be really valuable, perhaps. But that's all I'll say.
Look, I better bring this very free speech discussion to a conclusion. It's been a pleasure. I've so enjoyed the opportunity to engage with all of you and hear your diverse, rich and interesting views on this wonderful book. So I will ask you all to join with me in congratulating the panel for a really wonderful presentation. And it really has been just exactly the kind of seminar that we hope to have in our global public law seminar series. So thank you, everybody.
Thank you very much.
Okay. And good night. Look forward to seeing you all soon, I hope.